evening, good morning, good afternoon, everyone, from wherever you're joining us from. You are welcome to African Black Gold TV. This is a platform where we showcase Nigerians in the diaspora who are doing amazing things, as well as Africans in the diaspora who are doing wonderful things. Today, we're going to have a discussion on will. Why do I need a will? Thanks a lot, guys. Let's welcome our guest to the show, and that is Barrister Obadino. Please, sir, can you introduce yourself briefly before we get into the Q&A of this subject today, sir?
My name is Solanrewaju Bamidele Obadino. I'm a legal practitioner, and I base in Nigeria, Lagos, and sometimes I have my enterprise in Canada. And I'm happy to be here tonight at the invitation of my dear brother. And we are going to be talking about the importance of writing a will, what it entails, and the danger inherent in not writing one. And I hope that tonight's discussion will help quite a lot of us.
As a lawyer, have you written a will? If yes, what motivated you? If not, what is stopping you right now?
Of course, there is a proverbial statement in Yoruba land that whoever that we dash you clothes to wear, you will first look at what he's wearing on his neck. The literal interpretation of that is that ẹni tó bá ní ó máa fúnni lẹ́wù wọ̀ tọrùn ẹ̀ ni à ń kọ́ wò. I will be prejudicing myself if I come here tonight to talk to people about writing a will and I do not have one as a lawyer. Will is something that is extremely important to every human being. In as much that we all pray to live long and enjoy the fruit of our labor, a lot of people tend to misconstrue the genuine intention behind writing a will and have this primordial thought that when you write a will, you are probably preparing to leave the surface of the earth, but far from it. So I have a will. I've written my will, and it was not done in anticipation of death. I wrote it to tidy up things and prepare my family in order not to go through unnecessary problem in the hands of third party that does not know when we were gathering all of these things. The point at which a man should write a will, the moment you are able to start buying things for yourself, either chattel or fixed assets, which is land or landed property, you should definitely commence documenting what you have and how you intend to divest them in case you died on time.
Now, sir, what is the biggest misconception people have about writing a will? That is one question. The second question is, have you ever seen a family tore apart due to lack of will?
Okay, like I said earlier, I mentioned in my brief introduction when you asked me if I have written a will. Yes, there are a lot of misconceptions that surrounds writing a will. I have had opportunity to interface with quite a lot of my friends, people in my circle of influence. You ask them, have you written your will? And they will look at you that, why do I have to write a will? Do you want me to die now? So there is this general notion that once you sat down to write your will, you are preparing to die. I don't know where they got it from. Whereas writing a will is extremely essential. It's extremely important. It saves you and your family a lot of trouble. There are a lot of people that have invested into quite a lot of things because their family are not privy to that information. They died intestate, and people that are in custody of such important assets never disclose to their family. So when you started acquiring property, be it chattel, movable items, immovable assets, you are expected to start documenting them and divest them to various individuals that you have chosen to be the beneficiary of your will. But unfortunately, people felt that when I write my will, it's like I am, signing my death warrant. That is not it. It's far from it. And the second fear that makes a lot of people not to want to go into that is because of the attitude of some beneficiaries that you have listed in the will. If peradventure the documents get into the hand of the wrong ones, and before you call Jack Robinson, they might hasten up your debt for them to be able to benefit what you have stated in that document. So fear of death generally is what precludes quite a lot of people from writing a will. And yes, you asked a very germane question that have I seen instances where family were torn apart because of lack of will? My brother, the answer is a vehement yes. A lot of family have been torn apart because their parents who bequeathed the property to them died intestate. And because there was no written will for them to fall on, everybody start, doing a free for all. Ability to unite together to agree unanimously that, okay, let's divest this property in this manner became unattainable. That is why you see a lot of people taking themselves to court, sending killer to each other, relaying themselves, doing all manner of illicit things, all in the name of, inheriting a property. And even if care is not taken, there are instances where people wrote their will and still problem brew out of it. There's a prominent family in this legal profession that up till today, as I'm talking to you, they are still in court. Their father died years back. All the leader of thoughts in the legal profession tried their best possible to reconcile them. It wasn't a case of lack and want. It wasn't a case of abject poverty. This is a family that are well made, and every one of them that are beneficiary of the will have established their path in life. Yet, probably because of ego or some personal reasons best known to them, they were at each other's throats to the extent that some of them have started dying, yet the problem still persists. So when you are writing a will, it is not just picking your pen, engaging your lawyer to write a will that cured all the unnecessary acrimony and issues that might accrue later. There are a lot of other measures that you still need to put in place and ensure that you tidy up the loose end so that there will be no reason to contest the will when the time comes for it to be unveiled to the entire family.
Now, what happened when someone dies without a will? Who decide what happened to that asset?
Okay, in the course of my explanation just now, I have adumbrated on that particular scenario. That is when you say someone died intestate. When someone dies without a will, he died intestate. So it will behove on the family to approach the Ministry of Justice or the probate registry to go and commence the process of obtaining letter of administration. How does it operate? The family will sit down together unanimously, agree among themselves, appoint some individuals that will be assigned the responsibility of administering the estate. And that is what letter of administration is all about. All the property will be itemized. All the money in the bank will be identified. The entire thing will be valued upon payment of 10% of the total value of the property that is under reference to the probate registry. Then the appointed administrator will be the one to administer and share among parties. Let me use an hypothetical example for proper understanding. Let's assume a man died intestate having 2 wives or 3 wives. It will behove on them to come together, appoint one representative from each of the each wife, making 3 representatives, and they can also assign probably one of their uncle, who is their father relation, to be part of the executor of the estate. So those 4 individuals will approach the probate registry to commence the process of obtaining letter of administration. So all the assets, movable assets and immovable assets, will be identified, and there will be valuation reports on them to ascertain the actual value of those items. If the children of the deceased knows the banks where their father operates his bank account, they will take a letter from the probate registry to that particular bank, requesting them to oblige them the information of how much is in that account. This is extremely very delicate. Let me use this opportunity to bring to our knowledge my experience some years back when I was undertaking such a task. A particular family of 5 wives and 18 children approached me to assist them to process the letter of administration to administer the estate of their late father. Fortunately, before the man died, he took his second son along to a particular bank. I will not mention the bank's name, as at the time he went to open a fixed deposit account. So that second child has the knowledge of the fact that his father is operating a a fixed deposit account in that particular bank. On getting to the bank, we gave them the letter from the probate. They only remit the information in the current account and the savings account, which is extremely minute compared to what the anticipation of the deceased son was at that time. But because of his insistence, I went back to the bank and mandated the management of the bank to go into their record and check if peradventure the man have any other bank accounts. It was on that premise they now discovered that he has a fixed deposit account housing millions of naira. Had it been that the man did not go to bank with his son, as at the time he went to open that bank, there is probability that the information will not be known to the children. So after getting hold of the information, we went ahead with all our documentation, took the accredited, appointed administrators of the estate before a magistrate, a chief magistrate, to notarize the document. And also we got some elderly executors that comes along with them to bear witness that all of these people are unanimously appointed by the family. There is a particular document called Letter of Renunciation. Letter of Renunciation. This is to enable all other children, like in those family of 5 I mentioned earlier, family of 5 wives. Each wife nominated one of their son or children to be the administrator of the estate. The remaining children of the family has to fill a form called Letter of Renunciation, whereby they renounce their interest in being an administrator of the estate. And the whole essence of this is for balance of convenience, so that if we have to go before the authority, the banks, the probate registry, the chief magistrates that will notarize the document, we will not be having challenges of pulling 18 people together at the same time. So based on trust and mutual understanding, the appointed representative of each idigi, that is, each wife, represented the entire family, and we got, so all other children that are not listed as administrator, we sign what we call renunciation form. And that renunciation form tactically exclude them from being an administrator of the estate. And at the end of the day, after every documentation process was concluded, we paid the 10% of the total value into the coffer of the government of the state, and the remaining amount of money, including the assets, were being divested among parties based on the sharing formula that we all agreed upon. Another important factor that the probate registry will take cognizance of is, before divesting the property left behind by the deceased that died intestate, they will take into cognizance peradventure if he has some people he's indebted to, be it organization or individuals. Whatever the level of their indebtedness to these individuals or corporate body, once they were able to come out and justify that particular claim with verifiable evidence, the probate registry will go ahead to net off what the deceased is owing those individuals before charging the 10% on the remaining value. So that is how we handle the issue of someone that died without a will.
What are the key things people should include in their will? And at the same time, right, at what age should someone start thinking of writing a will?
Like I said earlier, once you have attained the age of 18 years, which is recognized under the law as stage of adulthood, you are eligible to start writing your will. I know somebody who started writing his will from the moment he was able to rent a house.
Wow.
Immediately he rented an apartment. I know somebody that started writing his will right from the moment when he rented an apartment. Immediately he bought television, bought carpet, bought clothing and some other items like that. I stumbled on a document in his room where he listed, in case I die earlier than anticipated, give my television to my younger brother, give my suit to my this, give my this to my this, and he listed them, and I was laughing that you will start pretending now like you are writing. He said, yes, so he said he had in their church, when someone was invited to come and talk to them, that the moment when you start acquiring property, no matter how little it might be, you are expected to start having your will sorted out so that there will be no acrimony over it in case you passes unexpectedly. So there are certain ingredients that must be inherent in any properly written, properly documented will for it to stand the test of time and avoid unnecessary acrimony. Number one, the name of the testator, that is the person that made the will. His name must be clearly stated in the will with a caveat, which is the introductory paragraph, stating that this is my last will. He must undertake in the will that he made it with his sane mind, that there was no inducement, he was not mentally derailed, is in his mental capacity as at the time he consummated the will. He must itemize all his properties inside the will. He must listed out the name of all the people that he intend to divest the property to. That will must contain the name of executors. Those are the people that will share the will, that will execute the will after his demise. And upon properly documented the will, he must append his signature in the presence of two witnesses to authenticate the validity of that will. And after all this has been done, the will is expected to be lodged at the probate registry for safekeeping. When you take the will to the probate registry, there's a special way by which it will be sealed with a red seal. As a matter of fact, it will be burned on it like a candle to seal all the edges of the will to ensure that there was no breakages until the time when the family called for it after the demise of the testator. In my practice, I've gone beyond the issue of ordinary writing the will. Upon completion of the documentation process, I will arrange for a camera, a video camera, set a ring light on the testator to read the will himself under the camera. That's I, so, Nigerian crime. This is my last will. I am the father of XYZ K. I married so person who gave me so number of children. I appointed A, B, C, D as my executor, and this is how I wanted my property shared upon my demise, and everything will be listed out in it. So it saves the family some level of stress when, after reading the will to them, you also bring out the flash drive to play the content of what the father said while he was alive. When the children sit back, watch their father on the screen, telling every one of them how he wanted his property shared. To a large extent, I do not see any reason why there should be any acrimony. The only issue that has happened in some cases is where some children feel disgruntled that their father has not taken good care of them in his will. There was a time I witnessed the reading of a will at a probate registry in Lagos before the setting ablaze of Igboshere, that the entire family came out of the place frowning. Some of the children were crying as they come out of that place. The father bequeathed properties to them with curses. I give you, my son, my house in so place, so time, you cause me sorrow. You also will not know peace. Your children will cause you sorrow. So, things like that. There was a case of a man I had some times ago that actually bequeathed to his son, one of his troublesome sons, 2 left leg of shoe inside the carton. Now, when they opened the will and read through, that is what they met there. So there is no way that particular son will be happy with his other siblings when he sees what their father bequeathed to them. So those are the things that used to cause problem in the course of executing a will. But where will are well consummated and well lodged at the probate registry, and it is well executed, there is hardly the problem of unnecessary acrimony that can result into fightings among parties. The most important thing is for somebody to be in his right frame of mind. He must not be mentally derailed. He must not be sick, as at the time he's doing everything, so that there will be no reason for contention.
Now, it sounds funny. I just want to take you back a little bit. The man that left the 2 leg, of shoes to his son, is there any tradition or any cause relating to that? That is one. And secondly, handwritten will, is it legally accepted?
Yeah, it depends on how you go about it. You see, what you are saying, whether it is traditionally accepted or not, it depends on the testator. It is his last will. It is how he wishes that his property should be divested. See, there is a restriction on anyone to deal with the property of a deceased person in a way that has not been stated in his will. You are liable to prison terms if it happens. So you must respect the last wish of the dead. Perhaps the person has incurred his wrath. I have written wills before that the testator left a stringent condition in the will. I try to maneuver him. I make him see reasons why you should not go that direction. When you are dead, you are dead. Let the living take care of themselves. Why the dead should take? He insisted. Say no, and I respected his wish. I went ahead and I deposited the will at the probate registry. I am confident that if the man passes, there is possibility that some of the children will reject the property he bequeathed to them based on the stringent condition he inserted in the will. So it is his choice. You cannot, he's the one that worked for it, and it's the way he wanted it shared that you must respect. Handwritten will, like you have rightly said, it depends on the circumstances surrounding it. It can be admitted as the last will of a deceased person. But the most proper way to go about it and have the validity of law is to engage a lawyer to help you in the process of documentation with all the legal terminologies, get it filed at the probate registry, and the record will be safe. Because if you do handwritten will and you keep it in your safe, yeah, I have a similar case at hand. I prepare a will for someone. We were to meet at the hotel for him to come and read the will, and after he needs to come around to proofread the will, but he came around and give some excuses that he cannot wait at that time. That I should oblige him the honor to take the hard copy I printed out for him to read home, to go and study it. I will bring it back the next day. I say, hey, this thing is dangerous. So he said, don't worry, barrister, I will be very careful. I gave it to him. He went home. Surprisingly, the wife saw the will where he kept it in the wardrobe. She saw it, she took a photograph of it, and called me and started lambasting me that I didn't advise her husband properly. Why would the husband do this? Why would the husband do that? I said, what are you talking about? I said, I saw the will that you wrote for him. So it's important to get things done properly so as not to create problem for yourself. Some people have been killed because of the exposure of their will to those who are listed to be the beneficiary, or those who felt that they were not well taken care of in the will.
In some culture, talking about will is like a taboo, it's like a bad luck. How do we change the mindset of our people not to, look into that direction anymore?
There is no hard and fast rule about it than to just continue the enlightenment, just like what you are doing today. I hope a lot of people will have access to this platform and see the importance of writing a will. You see, there are quite a lot of cultural norms and value that negate some things we consider most important in this our how do I call it, our technological age. But due to the advent of social media orientation and other important medium of disseminating information, quite a lot of things are being upturned. Even the stringent religion belief are beginning to wither out with proper access to information that could reshape the mind of those listening to such thing. I do not think at this age and time any tribe will still consider writing a will as a taboo. Like I've said to you, the only thing that makes people to get scared of writing a will at the early stage of life is because of the fear of death, hoping that once they write their will, they are signing their death warrant. So I believe strongly that proper orientation, proper exposure, consistent interaction of this nature will diffuse the thought in their mind, and people will begin to take it seriously. We all have good reasons to write. If I may ask you, Mr. Moderator, have you written your own will?
Honestly, no, sir.
You see? So perhaps you are from that tribe that see it as a taboo.
I do not see it as a taboo, but it's just like what I said, the awareness is not really there like that. I had it at the back of my mind. The only thing I did was not a will, but I only did what we call death insurance. That's the only one, because I don't want to leave problem for my children and for my wife. But the will of it, I think after this program, then I really need to think seriously about it.
Okay, you see, part of another problem that made a lot of people not to write will per se is not even the issue of death. Over confidence. Now, why would I be writing will now? I'm still 30 years of age. I'm still 40 years of age. We have longevity in my family. I will live up to 70, 80. So when I'm 60, 65, then I can start thinking of writing a will. Very, very wrong as a perception. You can write your will at any time. There is possibility that the content of the will might change. You may have a good reason to sell off some of those property. Whatever addition that you make to the property or the reduction that happens to the property can be taken care of through a further preparation of another we call codicil. Codicil is a name used to describe the document you prepare to update your will. And this can be done at any point in time. Anytime you file a codicil, it takes precedence over the subsequent one that you have filed ahead of time. So there's no, a lot of people are too lackadaisical about life. We don't take life too seriously. A lot of people just go about their things not knowing when death will strike. Quite a lot of lawyers don't have a will.
Some people, they leave nothing for their spouse, but they give everything to their children. Is that a fair deal? Of course, people will say, well, it depends on the man. But I mean, to you as a lawyer, like you said, I mean, is that a fair deal?
Well, it depends on how you want to look at it. Why some people prepare their will in that manner is because they have the opinion that the wife might go ahead and marry another person after their demise, and that he will carry all their property into the house of the new man that might squander everything. So they want to protect the interests of their children, which is uppermost to them. So that is what makes them to do that in most cases. But, there is this general knowledge that every surviving spouse inherits the other one that died. So whatever they have jointly together still belongs to their children.
Some billionaires says they won't leave wealth for their kids to make them work very hard. Smart or selfish?
My brother, it is not a selfish idea. It is a way of helping those children to be able to grant their feet in life. There are ways I look at it. There are some parents that are quite difficult and they are irresponsible to a large extent. They waste all their resources on frivolity. They prefer to be a socialite and be wasting money out there than to invest on their children. But I respect those parents that are wealthy and they use the resources to develop and train their children to become somebody in life, and now leave them to go and fend for themselves to cut out their own wealth. Because if you allow them to have uninhibited access to your resources, you will be shocked that they will become prodigal children after your demise. In fact, while you are still alive, I read something about 50 Cent recently, where he complained about his son, that he didn't want to work. All he wanted to do is just to come and be taking money and be spending money because his father is rich. Look at what Davido is doing. If Davido were to be some other children. He really need not to do all that he's doing. He can decide to go and sit down with his father and be working with his father like as his PA and sit back and be waiting for the best time that the property will be divested on him and he will start living the life of his age. But that young lad is trying all things possible to make his own money count. He's making his own wealth. If anything happened to the Adeleke in the nearest future, he will live long. If anything happened to him, whatever Davido and his siblings will get from their parents will be an addition to what he also have created for himself. You and I know that as of today, that young lad is a billionaire in his own regard. So he didn't sit back to wait that I want to inherit my father. So I don't want to see it as a harsh approach. I don't want to describe it as a selfish intention for a parent to insist that their own children must work for their own money. It's a good thing that every parent must emulate. You must let the children know that there is no free lunch in Freetown. You pay for whatever you buy in Freetown. You have to nurture them through the path of hard work. You must let them know that hard work don't kill, that it makes you great in life. When you are able to carve a niche for them, whatever you bequeathed to them later in life, they will multiply it. You cannot afford to nurture them on the path of luxury and let them miss their focus in life and not be able to take care of whatever they are going to live after you might have gone. Look at, there are a lot of homes that their father are multi-billionaire in our days when we were young lads coming up in life, that when you call their name now, they are nothing to write home about. None of their children has been able to surpass their record. They don't even come close, talk less of surpassing the record of their parents. We all know the story of Aliko Dangote. Have you heard of any of Dan Tata children that are as rich as Dangote himself? So the answer is there in the general public for whoever that cares to go and find out. So standing your ground that your children must labor to find their path in life is a good one for them. It will help them to shape their future.
What if a parent secretly has multiple family? Do the hidden children automatically get a share out of the properties?
Well, Section 42 of the 1999 Constitution is clear that no child shall be discriminated against by circumstances of his birth. Either they are secret or they are not secret. So far, they are children of the deceased intestate or testator. They are entitled to whatever the father bequeathed to them. Instances are bound that the father will confide in somebody of the existence of such children and certain provision will be made for their upkeep. Those children are victims of circumstances. They did not bring themselves to the world. It was through the consummation of the relationship between their father and the mother of those children that brought them to life. So you will not say that because they are secret children or that section of the Constitution I mentioned has already eradicated whatever call illegitimate child. No child shall be described as an illegitimate children under the 1999 Constitution. You cannot do such. So every children must have equal rights from their parents.
If someone passes away, nowadays it's all social media of a thing. Yeah.
Yeah.
Should their family have full access to their social media, email, or private chat? Because we've seen some people they will pass on, but still their social media account will still be there, and they can't even go in, they can't even do anything. Should parents also or people try to leave probably maybe a kind of maybe in the will to put all the details of the social media in the will? Is that advisable?
Definitely, of course. I've said it earlier. Whatever you have, everything that belongs to you as a legacy, you should be able to protect them. Look at our referred senior advocate of Nigeria, Gani Fawehinmi. When Gani Fawehinmi was, when he died and they read his will, there is this law report that has reshaped the image of Nigerian legal profession, Nigerian Weekly Law Reports, who he happens to be the publisher.
Yeah.
He bequeathed it to first trustee. Since the time he died till date, first trustee is the one carrying on the publication, and they remit the proceeds thereof in line with what has been stated in the will to the family, to the charity, and back to the legal profession. So if like it's an eye-opener to you, Mr. Nigerian Crime, when you start pencil down all that you have acquired, putting the Nigerian Crime platform on TikTok, Nigerian Crime platform on YouTube, Nigerian Crime platform on Instagram, what accrue out of it, how you want it diverse, who you intend to hand it over to continue, could be stated in your will. All of them are part of things that you have worked for in life. It saves you a lot of embarrassment. It saves the hard labor you have put in place to gather all of this platform together from going into extinction after your demise. If you are able to pencil down the information in respect of it somewhere, like if you write your will, for instance, you might state there that my Instagram account, IG name so password so this you quoted everything out. It's sealed up inside your web. By the time they open it and they share it to all the people that are supposed to take it, you might leave a code that so person should go to so it's important. Whatever you have, no matter how little it might be, when you are writing your will, get them sorted out in the will so that it will not go to the wrong hand.
Okay.
There are certain royalty. There are certain royalty that comes out of your artworks. So all of it can be taken care of in the will as well.
Some people leave wills saying their wealth must be buried or destroyed instead of giving it to the family. Should the law allow this?
Well, like I said, you know, the last wish of the deceased testator must be obeyed, though. Instances abound that parents will their entire property to charity, that they don't give it to their children. People can contest it that it is too harsh and that you shouldn't have done such thing. That is the wishes of the dead. The only thing is that if it was contested and there are circumstances of verifiable claim that probably is not in his right frame of mind when he was doing also, that can be repudiated. But if there's nothing to that effect, I don't think you have any reason to upturn whatever the deceased person has stated in his will. He might have his own good reason for saying that.
Can side chicks and baby mama inherit? If a married man secretly had kids outside his marriage, should those kids have the rights to his wealth?
Of course. If they are taken care of in the will by the deceased person, they will be taken care of.
But if he doesn't put them in the will and suddenly the baby mamas, they now walked in with kids, what will happen? Should those kids be recognized?
Well, if they are not taken care of if they are not stated in the will, it might be difficult. It depends on the executors and the beneficiaries of the will, if they'll be willing to accommodate it at that time. Because the last wish of the dead was not to incorporate them into the will. What we are talking about here is the last wish of the deceased person. If he died intestate, where nothing was written down, it could be construed that if he were to be alive, he would definitely wish to protect them and take care of them in his will. But where there was no will, where there is will and it was not stated in that will, to a large extent, it might be precluded. Perhaps he has been able to identify that they are bastards and they are not his own children. Anything could have happened that could have made him to preclude them from the will.
Who should inherit more? Should son or daughters inherit equal? Because in some culture they will say it's only the son that will inherit more. Or should boys get more, or should it be equal?
It depends on the culture of inheritance from certain domain. In Edo State, for instance, Benin, they have what they call Igiogbe. The first child is the Igiogbe of the family, is the one that inherits all the property left behind by the parent when they died. Out of his willful magnanimity, he can share with his siblings. But when you are writing your will under the Receive English law, you are expected to treat the children equally. It is not a case of saying that this one is a male child or this one is a female child. They are expected to be taken care of. The only reason why most African men tilted towards their male child more than their female counterparts is that fear of saying he will take my property to our husband's house. But if it's given to my son to run, it will still remain in the dynasty.
Can you see all these questions that I'm putting on the screen?
Did you hear about the woman whose
cat inherited millions of dollars while her family got nothing? Those days,
yes.
Fear of, is it a fair game, or is it just being foolish?
See, we have said all of this. If you continue to dig into the intention of the deceased person, that is his last will.
So it must be obeyed.
It must be obeyed.
When and where do we separate religion and legal terms here?
Like I've said earlier, there are a lot of things that we'll be looking at before such can stand. Inducement, there is this general belief that a lot of religious leaders have a way of brainwashing their followers to seduce them into doing some things that is against their willful intention. If it can be established that that is what played out, there is possibility that the will can be contested. But generally, when somebody had made a will, there are 3 grounds upon which it can be revoked. Number 1, if the will is not properly executed, if the testators does not have capacity to make the will, if the will is revoked or it was altered fraudulently. Where all of this is not stated, there might be some level of difficulty in revoking it. Someone came to me recently telling me that his father just died and his cousins are fighting himself and his mom over the property of their father, who happens to be his own father, elder brother. His father died. He bequeathed the property, the entire property, to his younger brother and other family member, and stated in the will that they should only train his children up to university level. And this man has a lot of property across the length and breadth of Nigeria. And the younger brother and the other family members shared it among themselves, that is what their father said in his will. And there was a level of doubts that because that man has capacity to alter the will by virtue of his position as at the time his brother died, that there is no way the man will have stated in his will that his own biological children be sponsored in school, and that will be the only legacy he will bequeath to them. And he will now instruct his own younger brother and his other siblings to share all the vast estates that he left behind. And I was asking the young man that, put yourself in the shoe of these children, that your father died, he bequeathed his property to his younger brother and his other cousins and uncle. And he stated in the way that and he was telling me that I have no reason to ask him that question, that is his intention, that is the last wish of the deceased, it should be obeyed. I said, so you want to continue the fight that those children are not entitled to their father's property? He said, of course, because it has been willed to his father.
Good evening, everyone. Good evening, hosts. Good evening, barrister. I'm greeting everyone in the house. In terms of will, when I met you, we said something about baby mama. In Nigerian constitution, because I don't know anything about the judiciary very well, I have to be honest. I strongly know more better about the Western culture and their laws more than Nigeria. But in terms of culture, I think I try most in that area. Now, in terms of will, that somebody have a child and they did not will that child through a baby mama, okay? Now, is it a Supreme Court or maybe High Court and the customary courts? Which one has more power in terms of a child? Because automatically, if the man is no longer alive, remember that the woman will demand DNA, right? To prove that this man is the father of my child. Okay. That is where the tradition need to be activated. And when tradition activated, then you now see justice. Automatically, that child becomes a biological child of that man. Either the first son it will be, or second son it will be. Because automatically, when biology, in terms of DNA, prove that this man.
Mazi, your network. Oh. We can't hear you again, Mazi.
Yeah. Okay. I said.
We can't hear you. Can you repeat it, sir?
Can you hear me now?
Yes.
Can you hear me now?
Yes.
Thank you. Now, we have customary courts. We have a Supreme Court. We have a High Court, right? In terms of a baby mama, a married man, and have a baby mama, we have a child for him, a son for him. Automatically have raised a will to the other children that he illegally married the mother.
No.
Remember.
Mazi, sorry, you can, Mazi, you can make your question short because we're not hearing you.
That's not my logic now. In terms of a culture, after the DNA test, and they prove that this man is the biological father. Oh my God.
Your network is bad, bro. Mr. Ajipo, in case you're hearing me, you can just unmute yourself. If you have any question, you can ask there. I'll put the mic, right on the speaker here so that our lawyer can hear you, and then probably maybe he can answer your questions, sir. Do you have any questions, sir, for the lawyer, sir?
Let me quickly say this before the question of that other man. Okay, I had part of what Mazi is trying to say. He asked a question about which of the courts have higher authority over some matter and some other stuff. That does not have any bearing on the issue at stake. We all know that the Supreme Court of Law, the Supreme Court of Nigeria, is the highest decision-making body in Nigeria as far as the judiciary sector is concerned, followed by the Court of Appeal and the High Court. Every decision emanating from High Court can be contested at the Court of Appeal, and from Court of Appeal, you go to Supreme Court. After Supreme Court, you can only have your solace in God. Their decision is binding. And I did not say that a child that is giving birth to by baby mama will not benefit will not inherit their parent. What I said is that if the deceased person died intestate, it makes it a bit easier for them to benefit out of it, because it will be construed that if the man were to be alive, he would definitely have taken care of them in his will, that I would not have left them in abeyance unattended to. And of course, you have said the most germane thing, which is to conduct a DNA test to ascertain the paternity of those children, so that no Dick and Harry can come up from anywhere and be laying claim that their children are for the deceased persons. And well, the second instance I cited is that if the man died in having a will, it might be a bit difficult for those other children to benefit directly from what has been bequeathed to other children. If he has already bequeathed all that he has and shared equally among the children, there might be some little challenge, except where there are some certain provision meant for taking care of his reserve for his estate that is to be jointly shared among party, that can be varied to accommodate those other children that that just came into the known as at the time that the man passes. That was what I explained.
All right. Mazi, are you okay with that answer? Okay. Let me go to Mr. IG Potterman on TikTok.
Yes,
Mr. IG.
Yeah, 100% correct, because it's culture. That means customary courts with our culture give the perfect judgment about that, so that those people who misleading public need to stop, because DNA and our culture and customary courts are the same. So you cannot say because they born for Europe or born for Ghana, because of that reason, he did not marry the mother, he will not inherit from that property. You understand? It's wrong. So when DNA is proven, you need to accept that your biological brother or your biological sister, and you don't need even lawyer, you need to fix your home by yourself. That is our culture across the whole Africa. So I really love that. Thank you so much for your response. Thank you.
All right then. IG Potterman, are you there, sir? Do you have questions, sir? Okay, hold on. I think Marita is hearing.
Issue raised by the lawyer. Thank you very much for all these explanations, Barrister. And you have unlearned me on some areas that actually, as a pastor, I think that I need to know. You know, so basically, there are so many of our people who actually, you know, like you rightly mentioned, when they say they want to write a will, it's like you are helping them to sign the death warrant, whereas it is not so. Now, what other ways can you use apart from, yes, you mentioned that when we do seminars like this or we do talks like this, it can assist. But you know, sometimes this traditional thing is so thick and so strong against our people. What other ways do you think we can use to talk to them? Because we have so many problems in our hands in the church that so many of them so believe that, unlike the Islamic religion, where it is enshrined on how, you know, the will can be done and everything, it is not specifically enshrined in the biblical whatever thing on what to do, especially when it comes to the issue of influence of tradition. So what other means do you think we can use to assist our members, to educate them, and then to be able to assist them out of all this challenge?
Thank you, sir. I worship in Redeemed Christian Church of God. Some years back, like about 7 or 10 years ago, I was assigned the responsibility of representing the church as the legal representative. Part of what I introduced to church at that time is bringing some lawyers to the church on some Sundays, once in a month, to come and educate us. In the course of that event, we handle issue of will. We had cause to talk to them about tenancy and landlord relationship, property acquisition, know your civic rights, know your social responsibility to the community, CSR, and quite a lot of other stuff like that. And I can assure you that on the day that the woman I invited to come and talk to us about will came to church, out of over 700 members as at that day, not up to 10 have anything called will. And the woman was so emphatic in his explanation and, the kind of probing question he was putting to every one of them. The woman told them that when you step out of the church, you can't be too sure whether you will get back home or not. Look at the time they went to kill some members of a particular church in Owo the other time. Nobody knows when he's going to die. When it comes to the issue of will, we should all adopt the doctrine of Boy Scouts. Be prepared. It will save your family a lot of trouble. It will save your family a lot of trouble. Somebody was sharing her personal experience with me a couple of years ago, that he worked with a particular boss that loves acquiring property, but he doesn't like involving his family member. He has some close confidants in his circle of influence that he normally carried along or keep some of those documents with. After his demise, not up to a year, his family were struggling, eating from hand to mouth, when they're supposed to live in opulence and riches. Their father had a lot of things, but because they were not properly documented and there was no will to guide on how to locate or divest all of those things, it fell into wrong hand. Hardly you see anyone that will be in custody of your property, juicy property, and they will bequeath it to your family at the end of the day. Let that notion continue to reverberate in our mind that only God knows the day of departure for everyone. So we should all be guided and be prepared. Part of what we can do is proper orientation through public enlightenment, church, social media platform. It could be school as well. We should engage ourselves in that regard. Continue to use every opportunity that comes our way to do it. I would love a station whereby Nigerian Crime probably feature this program also on TikTok, where we have close to 200 and something members at times. Let people come and learn. It's not going to be a banter throwing session. It's not going to be faja. It's not going to be the gossip on those people that always make headline. These are issues of life that will benefit a lot of us. So when we continue to use this opportunity to talk to people, it will sink into our system. Every one of us that have had this tonight, you might be able to share it to people in your circle of influence, that writing a will is not a death sentence. It's a way of safeguarding what you have. It's a way of protecting your legacy and your dynasty, so that it doesn't go into the wrong hand of people that do not really merit them. Let me warn every one of us. Beneficiary knows how to spend money more than the benefactors. People that you do not intend to allow to near your property will be the ones superintending it, if you do not have a proper documentation on how you want it divest. They will be the one to push your children aside and begin to lay claim onto what you have worked for. I know of a family that when the man died, his younger brother jumped upon all his assets and start selling it. He was arrested and taken to EFCC. So if he does not have children that are able to fight back in that manner, that would be the end of all the legacy that the man left behind. Proper documentation of what you have, and also cultivate the habit to have a trust ally among your children. If you are not too confident of the wife you marry, have someone that will be your close confidant, that will be the torchlight to tell the family that my father have this, my father have that. May we not die and lose all that we have worked for. If people died at times and they are able to look back, they will regret some of their action, that they never put everything in proper perspective before they pass it on.
Thanks a lot, Barrister. Now, yeah, thank you, sir. Who owns the house if a family, who owns a house if a wife fully finance house, but it's in husband's name? Should a family inherit it, or does it belong to the husband?
Like I said earlier, in marriage, if the husband died...
Can you hear me, sir?
Yes, I can hear you. I said I've said it earlier, that in marriage, the surviving spouse will inherit the other. Where it is, I don't see any reason why family will be the one to come and inherit the property that the man left behind when he have his own immediate family. He have his wife, he have his children. This can happen in some barbaric culture, but it has been repudiated up to Supreme Court on many occasions. You cannot deny the immediate family of a deceased person the asset of their parents, and not even where the woman is able to juxtapose her claim with verifiable facts, bank statement of account to show that she's the one that financed the entire thing. She will fight it to a standstill. So it belongs to the immediate family of the man, not the extended family. They have no place in the equation of sharing his property.
Thank you, Barrister. Thank you. Right, Barrister? Can you hear me now, Barrister?
I can hear you, my brother.
Can you hear me, Barrister?
Yes, I can hear you. I can hear you.
God bless you. I want to say something additional to what you said now. When I was a pastor in Nigeria, I see a lot of a breach of trust among we in society. What makes me to come to this program, and I'm very happy to see you as a legal practitioner. I'm happy to see you here. We need some amendment in Nigeria, especially in this area of aspects. And we, as a married man and a married women, need to start now to become a role model. Making a law is a different thing. Enforcing it is a different thing. Practicing it is a different thing. You understand what I'm saying now? These are three things.
Yeah.
So if we, let me say now I'm a grandfather anyway, let me say me now as a father. I married my wife with my pure heart. You know what I'm saying now? Pure heart. As a man, as a husband. And my wife married me with a pure heart. That is when that law will now articulate to become a reality. And we will now practice it with a good faith. When we are no longer in this life, in this planet, our children will follow on that legacy and protect their properties. And nobody has the right to invade it. Because when you see a man live a life of what they call insecure in marriage, it's a problem. When a woman live a life of insecure, it's a problem. Because when a husband and a wife come together, even in our culture, even in Christendom, it's a husband and wife that come together become one. And when a husband has a property, the wife need to know 100% what the husband has, because they are one. Applying to the woman, anything you have, your husband need to know it 100%. They become one. That is why you see today many children suffered when they lost their father. You know why? Because the man don't want to open up to the wife. And at the end of the day, you see the bank and the friends, business partner, will now take almost 95% of the property of the man disappeared. It's happening in Nigeria, in Africa. Then the children will become a beggar. The wife has no access to the property. He has no access to the money. The children has no access to the money. The money nowhere to be found. And at the same way, some women build houses without their husband knowledge. They have different banks without their husband knowledge. You know what I'm saying? Even if nobody knows anything about it. And when something goes wrong, the children will start suffering. One thing is sure. A property of a husband and wife belongs to the children. No man on earth can invade the property of the family when you as a man write a will of your own children. And their property as a husband and as a wife become one. Automatically, who is going to inherit these properties? That you as a father and a mother work together is the children. So their children will be proud of you as a father. You know what I'm saying now? So this is what you people need to make sure that to review some tradition for amendment, some laws, you understand what I'm saying now, in a customary court to be amended. You understand what I'm saying now? So that when you bring the culture up, it will become, because those cultures was already the microwave from the grandfathers. You see the culture that Igbo people practice in about 2,000 years ago, coming down each 100 years, they amend it. I don't know what I'm saying. Some people know, not everywhere. You come to West, you see some certain things start amending in terms of children. You know what I'm saying? The way they treat their wife, go on land properties. Somebody will die. You see the cousins, the nephews, they will enter inside the shop or into the company and vandalize everything. In the Western world, it's not acceptable. In olden days, it's not acceptable. Even though the woman has no kid, the property still remain until the woman decide to have a daughter or to marry another a woman to that family to have a child. The property of that man and the legacy of that man will continue running. But today, a lot of people have started shutting the family down, intimidating women. It's unacceptable. This is our culture in Igbo land, I'm telling you now. So those things need to be reviewed from those activists, from the lawyers like you people.
Well, I understand what you are saying. So I understand what you are saying, and I understand what you are saying, and I really appreciate the perspective from where you are coming from. You see, tradition has played a lot of role in making many families miserable, most especially from the southeastern region. I don't know how they were able to come about the law that says only the first child of a family will inherit the entire property of a deceased parent, and that is at liberty to dash his younger brother or younger sister out of it. He might choose not to give them. Nobody can challenge him for taking the entire thing. It's quite barbaric. But thank God that the Supreme Court has decided on a couple of occasions to address some of these inhuman customs. I call it inhuman customs. Now, in the southeastern region, female children are beginning to inherit their parents, unlike before, that they will consider it a taboo, that when you have a female child, you will not have any part to play in any of the property you left behind. I think this orientation talk of a thing cannot be left in the door, at the door of the lawyers alone. Every one of us needs to take active part in it. And that's why I said the primary thing that we put your family under some level of safety is to have a proper documented will. Where that is done, every other thing is taken care of. And thank God that quite a lot of states have created a unit that fight for the right of women. Like in Lagos State, where I based, we have a domestic violence unit at the Ministry of Justice, where a lot of issues of this nature are handled. There's another place called Gender Unit here in Lagos, where people can go to seek redress for any inhuman treatment melted to them by the family of their late husband or late parents. So, to a large extent, the awareness is becoming more and more well established. There's a body called FIDA in the Nigerian legal profession. They fight for all of these kind of causes. And I know that with this kind of program that we have now, many other people will begin to draw inspiration out of it, and we'll be able to enlighten ourselves more and more to ensure that people do what they need to do while they were still within the right frame of mind to protect their immediate family from any unnecessary frustration after their demise. I just pray that God will guide us to do what is right. There are quite a lot of people that will listen to what we are saying tonight. They will still not do anything. And what we are trying to guide against will still happen to them. But God will guide us and protect us and give us that grace to be able to do that which is right before we pass on. Is my sister having anything to say? Auntie, please introduce yourself.
Good evening, everyone. Good evening. Yeah, I'm Omalayo.
Okay, Oluwafunmilayo, you are welcome.
I am Omalayo.
Omalayo, okay.
Yeah. So I have a question for you, though. And you said something. You said about that the husband, if you don't trust your wife, right, you can entrust your will or whatever to one of your kids that you so much trust. And that brings me to
that was not what I said. That was not what I said. I didn't say he can entrust his will. As a matter of fact, when you write your will, you are not expected to divulge the content to anyone
anybody.
until after your demise.
Yes.
It will be in a safe custody at the probate office. But what I'm trying to say, in essence, is that any property you are acquiring as a father or as a husband, try to carry your family along. But I've seen cases where a wife connive with his concubine and kill the husband because of certain property that he has. So the fear of such might preclude a lot of men from letting their wife have the total knowledge of what they worth or what they have. So I now suggested that irrespective of that situation, we all need a trusted ally that will be able to carry along when we are taking some critical decision in acquiring wealth, so that they will not just go into oblivion after our demise. And the example I cited at that time was of a particular family I assisted to process their father letter of administration. I wrote a letter to a particular bank requesting that they should furnish us the information of how much was in the account of the man. And they only gave us the statement of savings account and current account that has less than 30,000 naira. We have they have 8,000 naira in the current account, and they have 21 or 15,000 in the other account. So everything is less than 30,000. But the second son of that man insisted that my father had another account in this bank, that I should insist that they should go into their system. They told us that there's nothing. The bank is in Ijebu-Ode, the branch is in Ijebu-Ode. I wrote a letter to their head office and demanded that they should go into their system to check and confirm that the son of this man is insisting that he followed his father to this bank on a particular day when the man came to open XYZ account. Lo and behold, they found the account that the man had a fixed deposit account, and over 30-something million naira was in that account. As at that time, If that man went there alone to deposit that money without that son, that money will go into oblivion. Nobody will know about it. So that's the explanation I was trying to give. Not that
I love
he
the
should
fact
leave
that
his
you're
wife.
able to expatiate further, right? Because when you were giving the analysis, when you're explaining, you didn't explain further. So it make it give rooms like, okay, maybe so that if your partner is not trustworthy, at least your own child should know what you're doing. And I love the
Yeah.
fact that you explain further what you are trying to.
I have actually explained this part at the beginning. I only cited this one that you had at this time that I was talking about it. I've given the illustration from the beginning. I explained how I processed letter of administration for the family, how I took them before the magistrate, how we went to the bank, how we went back to court to get another letter to the headquarters of the bank. I've explained that at the beginning. Maybe you joined us a bit late.
You know, it's not about joining, and I know about probate, I know about everything. It's not about joining,
Okay.
but the way you just
Okay.
expatiate now is different from
Okay.
what
How I
you
couched it.
yes.
I
The
understand.
way you expatiate now, right, is different from what you were saying before now. It's nothing
Okay.
about probate or not me joining, or the explanation now. It's more in depth and more layman understanding, not like the
I
legal
understand you.
term or
Yeah.
people. You understand what I'm saying? Not
Oh,
that.
I understand you.
So that's one. But that give me room to say that was the bank trying to cajole. Do you get?
To be
Because at this
honest,
thing you
to be honest with you,
yes, sir.
a lot of people died intestate and their property just vanished.
Yes.
Somebody has been arrested before in a bank. He went to the banking hall to make withdrawal in the name of a deceased customer of a bank. After he was arrested, they discovered that one of the staff of the bank
Was
was
the
the one
person
that
that gave
hinted
you,
in that
imagine.
there's a particular dormant account that have XYZ amount of money. That
Jeez.
same staff of the bank assisted him to perfect documentation, change the picture on the account to his own account, into his own picture, and he went ahead and generate ID card in that name, and he has been coming to withdraw money in the bank until he was caught. So these are the kind of money that people have access to in the bank. A
I
lot of
thank
people,
you. Continue, sir. Continue.
a lot of people die intestate. They leave a lot of stuffs in there, and nobody have access to them. Like the case of one man I mentioned the other time. It's a top shot in one of the. I won't mention the place because people might be on this platform that knows him. He died, and someone that worked directly with him was telling me that this person is my boss. I know that he's crazy about buying property. That have stumbled on so thing before, but he believes so much in so person. Family went to them to ask them that they say, no, the father
And they
did
keep
not keep
saying
anything in
no.
our custody.
Come on.
But
So
if the man has documented all that he has and submitted it in the probate registry, that's the first point of call for any family that our father died. We want to come and check whether he have his will deposited in the probate, and they will check. If it is there, they will bring it out, and everybody will know where they stand, rather than just left of everything in oblivion. And when death calling, you are not prepared. Any other person that is able to lay hands on them will be the one administering it.
thank you. That's an in-depth explanation and another angle to look out for. That reason why your family needs to know what is happening is not just because you feel like you want to die or anything. It's not because of future. It's because for you to know that something can even happen. It might not be my family myself. It could be like what you just said now. It's a neutral person entirely that is just
Yeah.
chopping where they did not. And I love the fact that you made a statement about reaping where you did not sow. That's the literal meaning of the proverb of what you
Of
said.
course.
That some
Of
people
course.
sir?
I said you are making points.
There's some people there is a statement you use that your brother, there's this word you use for it, sir. It's like literal meaning is reaping where you did not sow. You are just stopping. So that is
Yeah.
just what you just explained in a real in-depth manner. And that's really things that we should also look out for. It's not like because I want to die now or anything. Just for example now, like, yeah, this is a good question to even ask you about popular late about Ibinigwe or
Wigwe.
something, yeah, that died. And is it a rightful thing when there is a will already, it's been read and is in the name of a rightful person and the family is countering it?
I want to say this categorically, that quite a lot of people is getting the entire thing wrong.
Okay.
And I want us to go back and properly check and understand what the grievances of the family was. The family were not adverse to the interests of that young lady from
The
inheriting her parents. The answer is no.
okay.
But there are some steps that the bank is taking that they considered a bit inimical to the progress of the family. They are saying that this girl is our daughter, is the daughter of our son, irrespective of the fact that they have bequeathed so much wealth to her. Let her have unhindered access to the family. What I discovered recently is that it appeared that even the stipend they normally give to the father of the late Wigwe had been stopped by the bank. So they are trying to contest shrouding the entire process of divesting his interest, how do I call it? His legacy in secrecy. That's what they are only asking, that they should come clear and let everything be in the spotlight. That they should not just. They
hide
are also,
under the girl to
yes,
carry
to
out that.
siphon a lot of things. Yes, that's what they are trying to do. So it's not outrightly that they are contesting the validity of the lady right to the property of her parents. No, that's not my own understanding of what the issue is.
Okay. Okay, now let's leave the Abat out of it now. Like the question I asked now, that okay, can someone contend the will, a rightful will to someone, and maybe someone is not contending it? Let's say, for example, maybe amongst the children, a particular will is will to maybe more favorable to some than others, and the others are not favorable, are contending it.
What is important for every parent to do when writing a will is to ensure that the will satisfy all the necessary conditions,
Okay.
and not expose it to revocation or being set aside. Because where you can establish element of fraud, inducement, or that the person that make the will, the testator, is not in his right frame of mind, all of that can vitiate the proper execution of a will. That a will can be contested. Yes, it can be contested.
Good.
In fact, there are avalanche of cases in court that emanate from sharing formula of a will, where some children will come up and say that so person is the one that induced their father to do this and give him all of that, that if not the inducement, why would the father leave all the other children and bequeath so much to this particular person? There's a particular family in this our legal profession that are in court till today since their father died. Their case is not a case of lack. It's not because they are coming out of abject poverty and that they wanted to take chunk of that will to the benefit of themselves. No, it was mere ego. Because all of them are made. All of them are senior members of this legal profession, and they are still in court till today.
Right.
They have not been able to overcome the temptation of resolving amicably. Some of them are dying already, yet their siblings, their children are taking over the case after them. They are still in court till today.
Thank
A
you.
lot of instances abound where will is contested. Okotie-Eboh will was contested to a large extent. The former premier of Midwestern region, his will was contested. He willed all the entire property he has to his mistress when his surviving children are still alive.
Voila.
So,
But that
there
one
are
is
lots,
justifiable to contend that, sir.
but it is his last will.
Voila.
Somebody will his property to cat, and he has surviving children abroad. It is his last will. That's how he wanted his will divest, and you cannot deal with the last will of a testator in a way that is different from what he has stated in his will.
Come on, it is well. It is well. So that means one can actually contest a will if it's not in your favor and you feel like there is a ground
Not if
for
it is not in your favor. You cannot just bring up a frivolous application to say you want to contest a will out of greed. No. If the will falls short of those
local standing,
explanation, legal standing, if it does not satisfy the legal requirement, then it can be contested and it will be revoked or set aside.
So if it's not set aside now, what will now happen?
If it is set aside, the authority of the state, that's probate registry, will work out the modality of appointing executors and administrators that will administer the will in a way that will be in conformity with fairness, equity, and natural justice.
So there is more to will writing. You need to understand the in-depth, the don'ts and don'ts, what it entails to write it. Right. Thank you. Thank you. There's a question here. Secret DNA test before inheritance. If a man died and the family demands a DNA test before sharing his wealth, is there a reasonable or is this reasonable or disrespectful?
If the man has not contested the paternity of the child while he's alive, you do not have any, and he has already listed the person in his will. You don't have any right to do that. You don't have any right. The only instance that I will not be able to contest it if family demand for such is where the person die intestate and the child just come from nowhere. You can contest it. The legal wife can contest it that no, my husband never told me that he has any child outside. So, and at the end of the day, they can call for DNA test, and once it is carried out and you are able to ascertain that it's the child of the person, it behoves on you to also accommodate him in a way. It might not benefit as much as the other children of the marriage. But I mentioned the other time, Section 42, subsection 2 of 1999 Constitution is to the effect that no child of born in Federal Republic of Nigeria shall be discriminated as an illegitimate child by the particular circumstances of his birth.
So, by law, there is no
illegitimate child.
By law, but culturally and traditionally, right, whereby we have a lot of onus, like when Mr. Maxi was explaining about the what happened in the eastern part of where we come from in Nigeria, right? And they have their own news whereby whether you are learned or non-learned, whether you are the firstborn or as female, a main child is domineering, a main child have the power to talk, a main child, they believe in that. So
Yeah.
how are we going to strike a balance with that?
Well, like I said, the court is living up to expectation in that regard, and a lot of barbaric cultures has been upturned on a couple of occasions. I've read a case where female child were allowed to inherit their parents in the southeastern region. So it's just a matter of contesting those barbaric law. Any law or custom that run nugatory to any provision of the 1999 Constitution will be rendered inconsistent. It will be rendered null and void to the extent of its inconsistency with that particular provision of the law. Wherewithal and the strength to contest it is what is lacking in many people. Fear of unknown. A lot of people say, don't contest it, or they will kill you. They have African power, they will kill you. They will send a killer to you, they will do it. So that fear of unknown makes a lot of people to chicken out and eat the humble pie.
Well, we still have a lot to do with cultural belief, whereby some people don't still even obey the law, even after passing judgment that you need to go ahead with it. Some people don't obey the law. They still say it's still the main child. So you as a female, you don't have a say to it at all.
Yeah.
Thank you so much. Thank you.
So we've got
I love. Do you have a question?
No, on TikTok. So I want to put the microphone there. We've got Mark and IG Potterman. So Mark, please, are you still there? Mark.
Yes, I'm here. Yes, I'm here. Sorry, I was trying to unmute.
Please, they're hearing you. Kindly go ahead with your question, please.
Okay, thank you so much, sir. So, actually, thanks for the explanation. I was just like wondering when you mentioned the case of the former premier of the Western region, that maybe after, because most times I know that most discovery about will are always discovered after the demise of the writer of the will or the owner. So after the person has died, there's no other way to confirm. And it's now found out that maybe the content of the will duly certified, though all the legal processes were done, everything was done right, perfectly. But the content is maybe like questionable, something like, okay, willing everything, all your property, to a mistress. So how can people still go ahead and contest such will, even though it has been seen that all the necessary legal steps were taken to sign or to come up with this will, or to see or validate or authenticate this will? But in some way, maybe the will still looks unreasonable, like willing everything to a cat, or willing maybe 90 or 95% of properties to a particular beneficiary. So how can people still go ahead and contest this kind of will that is duly signed, but to them it looks maybe irrational?
Okay.
So that's just what I feel like asking about. Thank you.
Okay, yeah.
Well, I've already explained it.
Yeah,
I've already explained it. When my sister was asking the other time that can anyone contest against will, and I cited instances, even where it was not will to cat, it was not will to mistress, people still come and contest it. I've mentioned the case of a particular family where all the children are multi-millionaire, and they still went to court to contest the will of their father, and the will has not been settled till today. Everyone that matters in legal profession has invited them for a truce, but the ego will not allow them to allow it to subside. But that is just that. In the case of this particular case I cited, you know, how can somebody have children, of having children, and his entire will was vested in someone considered to be concubine? The explanation I had was that he was abandoned by his immediate family at that time, and that it was only the mistress that was there for him. And that was why he did it out of annoyance. But, you know, it will be strange if the children just allow it to slide without coming up with such contention. I also mentioned a similar case the other time when I was explaining this thing, that a particular man will 2 left leg of shoe for his son because the son was extremely troublesome when he was growing up, caused the man a lot of wahala, police station today, another place tomorrow. So the guy is just too troublesome, and the man waited until when he was passing. He didn't allow him to benefit anything out of his property. I also mentioned here tonight where someone assigned me the responsibility of writing his will. He asked me to put in there some stringent condition that I know that might lead to litigation in the nearest future when we wanted to execute the will. But he insisted, since that is his last wish, I advised him against it. But when he insisted that I should allow it to be like that, I left it. I didn't bother to upturn it in any way, since I don't have that capacity to do it. So everybody should just try to ensure that the will satisfy those requirements of law. And I explained to Nigerian Crime at the onset, I said I go beyond mere writing when I'm doing will perfection for any client. I will also make you sit down, set camera in front of you. You will read it so that they will know that you are within your right frame of mind when it is executed. A lot of parents, at the end of their will, they place curses on anyone that will upturn whatever they have done inside that will.
All right, sir. It's Mr. IG Potterman also have a question. Mr. IG, are you there, sir? Okay. Please, you can go ahead with your question, sir.
Yes. In a case where a person just buy without anything, and then he had his legal wife, and then married another person who, one, did not pay a dowry because the parents did not allow him to pay the dowry because he was a Christian, and the lady in question is a Muslim. And she had to now, after they had 2 children, she had to go and remarry. Now, the question now is this: what is the position of that woman who went to remarry as relates to the will sharing? Definitely, from what you have lectured us, I've understand that there's no bastard child. Fine. Now, definitely, the child, the only child from the legal wife, definitely has something within the will. The wife, too, who still remains in the house with the child and will remain with him till death, definitely will have a share of whatever thing he had. The 2 children from the other woman who is a Muslim, but because of religion, the parents didn't allow him to pay the dowry or do anything. But they had 2 children. The 2 children, they are not bastard by law. Now, the question is, what is the position of that woman who has gone to remarry? Does she have anything in the case where there's no will on ground?
Okay, Barrister, sir.
Well, it's clear if you have gone ahead to remarry another person, you do not have any part in the affair of the man's will. The only people that can be accommodated are the children, and that is if the family are aware of it. If the family are not aware of it, they can call for DNA test. We've explained this earlier. And once the DNA test confirms that it's their children, they will definitely take care of them in the will. That is if the man die intestate and they have a lot to share among the children. But if the man did not die intestate and he did not accommodate all these children in his will, and he has already divested the will in the existing children that are legitimate, that are in the family prior to his demise, it might be difficult for them to be accommodated in such situation, except where there are certain money set aside for the running cost of the estate, or probably meant to be shared among children in the family. Those can accommodate them. But aside that, there's a lot to that. Nigeria crime.
All right. Thanks a lot, sir, Mr. IG. Thank you.
Right, sir. Yes.
Thanks for coming out. Thank you, sir.
Appreciate
Yes,
it.
thank you. All right. I mean, Barrister, sir, probably maybe if you just want to summarize everything, because I mean, you're not in your base right now. You travel from one end to the other, so that we can leave you for you to relax more. Maybe if you can just summarize it, and then we just call it a day. And we try to choose another topic for next week Friday.
Okay, thank you, sir.
Sorry, sir. Omalai, do you have something to say?
No, sir. No, I've asked him serious questions.
Okay. So, Barrister, please, maybe you can just summarize everything, and then we can call it a wrap.
Once again, I thank you, my dear host, Nigerian Crime, and our esteemed audience that has been listening all the while at the beginning, from the beginning of tonight, all-encompassing and highly engaging topic. Will is essential for every man. Writing a will is not a death sentence. Writing a will does not mean that you are going to die the next day. It's important to take care of a lot of things, put all your loose ends together, properly arrange your property, and put your house in order so that there will be no acrimony, contention upon your demise. And it also safeguard you as a person and all your investments from getting to the wrong hand, so that those who do not know when you were running around to accumulate all of those things will be the one benefiting out of it after your demise, when your immediate family will be languishing in lack and abject poverty. I encourage everyone to take a proactive step in ensuring that whatever they do in terms of financial investment, property acquisition, have a confidant among your immediate family that will be your third eye in monitoring all of this in case of your demise. They will be the one to tell the general public where your interests lie. Unlike if you don't have anyone that will be able to unravel all of this upon your demise. And I've also said that when you are writing will, ensure that they satisfy the legal requirements, that it will validate it, so that every effort put in place in consummating that wonderful document will not go into nullity after after it is being tested at the court of law. And I encourage you to please continue to like and join the channel of Nigerian Crime. I think Black TV, I don't know. I forgot the name.
African Black Gold TV.
African Black Gold TV. Let's continue to subscribe to that platform. There will be more of this edition in the nearest future. My name is Olanrewaju Bamidele Obadino. I am the chairman of the Nigerian Bar Association, Etiosa branch in Lagos,
Wow.
Nigeria.
Congratulations.
You see
Thank
that
you.
this platform, you see, say the platform not be mama you, eh? Now Ghana we just carry call like this. Thanks a lot, sir. Well, can you just wrap it up so that we can, get out of
Okay,
here? And then,
Leonard boss. I will not say Leonard Collie, Leonard boss. Congratulations. I guess it's this
Thank
new
you.
legal year. That means you are going to become Lagos State or chairman Nigerian Bar Association for NBA. Congratulations! It's we want to say thank you for this. Why are you laughing at me? We want to say thank you for this. You coming up and share more in depth to will, because the people like what you say. People always forget when it comes to will writing. First and foremost is troublesome voila before you start changing, you know. But the way you were able to put words together and explain further, it means that you're not dying tomorrow, you're not dying now, but you're just putting the necessity in order. And it's not because maybe you don't trust anybody, but because it needs to be done for the future of your family, so that nobody will come and eat where they did not plant or do anything. We want to appreciate your wisdom, we want to appreciate your time, because you're traveling and you're able to even give us your time to come here. And we are still going to come here next week Friday to discuss another aspect of will. And we are very grateful to your time, Barrister Badino. Thank you so much, sir. And to our audience, thank you for engaging on African Black Gold. Please go. There are a lot of updates, a lot of video. Just please listen and put your comment, ask your question. We'll get back to you. And our family on TikTok, thank you so much for ever being there for us. Thank you for always looking out for that green and white NC. Is he there? Where is he? Thank you. We appreciate. Thank you so much for Daddy IG. Thank you so much, Daddy. Thank you, IG Potterman. Thank you so much, Max. I know you're online. You're asking question, and we miss everybody. We'll be here tomorrow on TikTok. So at 9 p.m. Nigerian time. So on this note, please don't forget. Think about what was discussed today, because it's an educative one we had today. Ponder what needs to be done for your family, what needs to be done for yourself. Do you want to leave your family in disarray? Do you want to leave yourself in disarray? Just ponder of what we discussed today. And if you have any question again, please reach out to the hosts and you will be able to reach out to Barrister Badino. And thank you so much once again. On this note, we want to say, oh,
Hold up,
see you
boy.
tomorrow on TikTok.
All right, guys. Thanks a lot, guys. See you tomorrow on
Bye.
TikTok. We appreciate you guys. Bye bye. Thanks, Somalaya, for coming by. Thank you.